All right, I have chat. Well, at least in theory, I have chat. And I do appear to be live. Okay, so need to tell people. All right, I had to take a ration of shit from WTT. Thank you, sir. It's appreciated. Hello, children. Yes, indeed. All right, so we're going to talk about a few things. We are going to talk about. I killed the thingy. We are going to talk about Springer, but we're going to start off Springer. We are going to start off with. It says I have that tab. It's just hidden. I need to move that down a little bit. Are we good now? I don't even know if we're good now. I'm good. Are you good? I'm good. Chat be chatting. That's the important thing, right? Chat be ever so much chatting. All right. What was Coded going to do without chat? Oh, I don't know. Anyway, all right. So I do sub to my man Writes On. I like the guy. I don't agree with him on a whole lot. Yes, you are still blocked, Pants. Go away. But on his community page, he had a link to this. And this is from some cat named the Civil Rights Lawyer. Now, I got a lot of balls for saying some cat named Civil Rights Lawyer when he has 400,000 subscribers and I have like, what, 5,000 or something like that? I don't even know. Anyway, so it's this. Wow! Look at this. The elected prosecutor from the Officer OD hoax case that was exposed in several of my videos issued a press release today, personally attacking me, but not before turning the comments off. If the allegations weren't fabricated, then why did he stop the prosecution and request the charges be dismissed? Why did he stop the prosecution and request the charges be dismissed? We're gonna have to. Ah! Things are happening. Boomer tech. We're gonna do that. All right. Boomer tech. You wish I would spank you, pants. I mean, if you're good looking enough, I might. But that's neither here nor there. Don't abuse it. I let you back in. Don't abuse it. So anyway, if the allegations weren't fabricated, says the civil rights lawyer, using his logic, then why did he stop the prosecution request charge to be dismissed? He seems to have missed that explanation. Reading is fundamental, folks. Can we make this bigger? That's what she said. All right. Made it bigger. I know. That's for you, Pants. We made it bigger for you. Charges against defendant who caused 2 police officers to overdose dismissed. Defendant to be prosecuted in federal court. Remember what we're looking for. Why was it dismissed? And he seems to have missed that explanation. On September 27, 2022, Keith D. Adams was charged in Fayette County, West Virginia, with felony drug possession and 2 counts of attempted murder regarding 2 Oak Hill, West Virginia police officers. The criminal complaint filed against Adams alleged he intentionally exposed 2 Oak Hill, West Virginia police officers to fentanyl with the intent to kill the officers. Why are you wet? Why are you both wet? Why you come over here to shake? What the hell? What the hell, Bobby? There's the boy. There's the boy. Yes. All right. There's one of the boys anyway. Okay. So now you've seen a dog. Fentanyl's terrible. A criminal complaint filed against the village. He intentionally exposed 2 Oak Hill, West Virginia police officers to fentanyl with the intent to kill the officers. Both officers were treated at the scene by EMS and then at a local hospital emergency room. Thankfully, both officers fully recovered. The Office of the Prosecuting Attorney for Fayette County recently dismissed the charges pending against Adams in Fayette County after consultation with the U.S. Attorney's Office for the Southern District of West Virginia. In discussing the case, it was determined that Adams was facing far more serious penalties for his alleged conduct under federal law versus state law. Additionally, the evidence recovered at the scene was needed to prosecute Adams in both state court and federal court, which made simultaneous prosecutions in state and federal court problematic. In light of the proceeding, a decision was made to defer to our colleagues in the U.S. Attorney's Office for the prosecution of Adams, and the charges in Fayette County were dismissed. Now, right there, which tab is important? All of them, sir and or madam. Right there, we have the answer. Right there, we have the answer. But to confirm that we have the answer, for why they stopped the prosecution, I'm going to go to this tab right here. This is WVVA. The redundancy with the V's is redundant. And we're going to look in here, and he says that this guy, Siberti, that's Fayette County Prosecuting Attorney Anthony Siberti Jr., presumably, I don't know, this guy, maybe this guy, I don't know, whoever wrote this. This is the Office of Prosecuting Attorney. So Siberti says the attempted murder charges in Fayette County can still be prosecuted at some point, which means the charges were dismissed without prejudice. So you got these little things. I don't know if I'm educating a civil rights lawyer. I doubt he watches my stuff, but he probably should, because I am not just good looking. I'm not just funny, but I'm intelligent and informative. Just ask coded. So what happens is they say that they can't prosecute both at the same time. You have a right to a speedy trial, and so you're on a clock. You know, as soon as you file charges, you are on a clock to get this thing run through. And so what they've done is they've dismissed the charges without prejudice to allow the federal court, because they only had enough evidence. You know, they had evidence. The same evidence was needed for the federal prosecution that was needed for the state prosecution. So evidence can't be in two places at once. So they let the federal court proceed ahead of time. They also said that they were going to have the state court stuff, or try to have the state court stuff used in the sentencing phase of the federal prosecution. But that's really it. I mean, that's really it. They're just saying, okay, feds, you get to go first. That's what they're saying. If the allegations weren't fabricated, then why did he stop the prosecution and request the charges be dismissed? Because he was going to let the federal court go first, because of that stupid right to a speedy trial, which means that they can't hold him indefinitely on the state charges without actually bringing the case to trial. That's why. I mean, I don't have a cool fancy name like the civil rights lawyer, but I mean, I thought that was fairly obvious. But I guess if you want to be cool, and everything, and pretend, what they do to attack him? What they do to attack this guy? Let's find out what they did to attack him. Recently, in response to the charges being dismissed, John H. Bryan, a lawyer from Union, West Virginia, who bills himself as civil rights lawyer, they got his name wrong even. It's the civil rights lawyer. See, it's the civil rights lawyer. He's not just a civil rights lawyer. He is the civil rights lawyer. The civil rights lawyer. Fucking the cojones. Has released 2 videos on his YouTube channel regarding the Keith Adams case. Mr. Bryan's videos regarding the Adams case contain significant misrepresentations as the evidence in the case, and Mr. Bryan made material misrepresentations in his videos about other aspects of the case. The most disturbing aspect of Bryan's videos is he wrongfully accuses 2 police officers involved in the case of fabricating the allegations against Adams. But you know, he's doing this for clicks and views, right? He's got that monetization. He's advertising his videos. Come get the clicks and views. Come get them, boys. Clicks and views for you. Clicks and views for me. All right. So stupidity resolved. On to the next. How are we going to do this? On to the next. All right. All right, so this is the Springer docket. This is Springer, right? Here we are, Springer docket. What did we have going on prior that I covered? Now, one thing I want to point out is the order on the motion for reconsideration. I just bought it again, so hopefully it's right. Let's see if it is. No, it's not. So I had seen this before, and I had passed on it like everybody else had. But then I got to thinking today. I listened to Frog on the way home. Poor feller was very tired, and all of these were poorly written. So he did 40, 41, and 42. No, 39, 40, 41, 42. So if you want to get a reading of them in ye old English accent, then you can go that route. Anywho and anyway, these were poorly written. Anywho and anyway, so what we had here, we had an emergency motion for reconsideration, and then there's an order on that motion for reconsideration. So I'm going to start back a little ways. So here's the back a little ways, right? This is the order granting that you haven't seen before. I have read, but you haven't seen it before. I'm going to go back one. This is the order granting, in part, plaintiff's expedited motion to reconsider. So it's granting, in part, the motion to reconsider. The matters before the court on plaintiff Springer's expedited motion to reconsider. In his motion, plaintiff asks the court to reconsider its order denying his motion for a temporary restraining order and preliminary injunction order, on the grounds that the order erroneously found that he failed to provide an affidavit, number one, in support of his motion for a temporary restraining order and preliminary injunction, the motion, or number two, verifying his complaint. Plaintiff explains, and then it at one. All right, so no, that is not it. Okay, plaintiff explains that on August 10th, 2023, he filed a, quote, notice of completion of briefing, service, and additional information. The notice of completion of briefing just means everything's been briefed, and it was $1.10, by the way, for the document. Thank you, Bill Cook. Asshole. Donate to my G-String account, Bill Cook. Donate, you cheap bastard. So notice of completion of briefing, it just says, hey, all the briefing's done, and the court can make a decision. So there you go. So plaintiff explains that on August 10th, 2023, he filed a notice of completion of briefing, to which he attached a declaration in support of his motion and complaint, citing the declaration ECF number 25-2. Now we have this little bad boy. This is a footnote. In his motion to reconsider, plaintiff pointedly admonishes the court for overlooking the declaration he attached as an exhibit to his notice of completion of briefing. He further admonishes the court, I don't think the court really liked it, by the way, for overlooking the declaration because in his underlined or underscored second notice of completion of briefing, ECF number 32, he incorporated the underscore first notice of completion of briefing, quote, and all attached exhibits therein, end quote. Typically, a party wishing to file a verified complaint either includes the declaration under penalty of perjury required by 28 U.S.C. section 1746 in the complaint, all underscored, still underscored C, for example, Peck versus Midland Funding, LLC, or attaches a declaration as an exhibit underscored to the complaint, or again starting the underscore, C, E.G. Stewart v. Guzman. Similarly, a party who wishes to support a motion with an affidavit or declaration or any other evidence attaches it as an exhibit underscore to the motion and underscore cites it in the motion. This is the first time the court has seen a party attach a declaration verifying a complaint to a notice of completion of briefing filed 2 months after the complaint. It is also the first time the court has seen a party attach any sort of evidence in support of a motion to a notice of completion of briefing, simultaneously indicating the briefing is complete and including additional information for a court to consider seems anomalous. It does. Briefing's complete. Oh, by the way, we got a little bit more attached. A notice of completion simply notifies the court, quote, that the motion is ready for decision, end quote. As such, the court does not review notices of completion for substantive argument or evidence. Because plaintiff filed his motion 2 months before he filed his declaration, he did not cite the declaration in his motion, underscore C, ECF number 1 at 11 to 15. And although he could have drawn the court's attention to the declaration by citing it in his reply brief, he did not cite it in his reply brief, underscore C, ECF number 33. Although this seems gratuitous, for all future filings, the court directs the parties to draw the court's attention to evidence it wishes the court to review in its actual briefings. Seems like a pretty standard thing to do. In the declaration, plaintiff states, inter alia, I am familiar with the contents of the complaint and motion, and I verify that they are true and correct to the best of my knowledge. ECF number 25-2. The court accepts that plaintiff has, in fact, filed a declaration in support of his motion and complaint. Because the court's order states that plaintiff failed to file an affidavit in support of his motion and refers to the complaint as, quote, unverified, end quote, the, quote, offending language, end quote, the court will issue an amended order that accounts for the declaration and omits the offending language. However, because the amendments do not alter the court's conclusion that plaintiff has failed to carry his burden of establishing entitlement to a preliminary injunction, plaintiff's motion for reconsideration is denied in all other respects. Footnote 2. The court finds the remaining arguments and assertions raised in plaintiff's motion for reconsideration are without merit. Accordingly, it is granted, in part as follows: amended order that accounts for the declaration and omits the offending language. It is never a good idea to piss off the judge. And the judge, very calmly and very patiently, uses language that indicates the judge is not particularly pleased with the tone or tenor of the motion for reconsideration. So, because it's been a fair minute to reacquaint ourselves with the order denying plaintiff's request for a temporary restraining order / preliminary injunction, we're going to read this again. If that bothers you, well, I'm sorry. This matter is before the court on plaintiff James Springer's emergency request for a temporary restraining order, which the court construes as a motion for a preliminary injunction that is contained within the complaint he filed on June 9th, 2023. Defendants yada yada filed a response on September 5th, 2023, to which plaintiff filed a reply. The court has reviewed the parties' submissions and finds that a hearing will not materially assist in the resolution of this matter. This just says, I have authority, saying I don't have to give you an oral argument. Upon review of the complaint, motion, response, reply, the record, and the relevant law, the court will deny the motion. According to the complaint, plaintiff is an independent investigative journalist who produces content intended to expose to the general public cases of government fraud, waste, and abuse. The plaintiff contains 2 paragraphs numbered 8. The court citation to paragraph 8, in parens 2, refers to the second paragraph 8 sequentially. Plaintiff displays content on a YouTube channel he operates called James Freeman, which has approximately 444,000 subscribers, more than the civil rights attorney. Quote, the content plaintiff posts on his YouTube channel and on other social media platforms often receives tens of thousands of views and frequently sparks robust debate about matters of public interest related to constitutional rights, the workings of government, and other related matters. End quote. On January 27, 2023, plaintiff visited the 7th Judicial District Court in Torrance County, New Mexico, ECF 29-2, citing James Freeman, underscored sheriff and deputy stand up against bad New Mexico judiciary, Gordon Bennett, YouTube, posted February 20, 2023, hereafter, Bennett video. This is footnote 3, available at this place. Oh, shiza. I didn't mean to do that. Son of a bitch. Son of a bitch. Did I kill it? Fucking killed it. God damn it. God damn it. One misclick later. Yada yada. And that was it you? We'll do it live. It's this one. There we go. All right. We accidentally clicked on that. That's a link. Merv, please put this on 1.75 times. Sorry, Paul. You fuck with. All right. And we're here. Here we are. Everywhere you go, there you are. On that date, the state of New Mexico still had a mask mandate in effect for its courtrooms due to the public health emergency caused by COVID-19 pandemic. Footnote 4. The New Mexico Supreme Court rescinded the courtroom mask mandate on March 31, 2023, and the court takes judicial notice, apparently, of those. So also see this in the matter of New Mexico, blah, 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 yada, yada, and then footnote 5, available at that. Okay, so the court took judicial notice of that order as well. Additionally, the judicial branch of New Mexico had rules governing conduct and security in New Mexico's courts, including number 1, no photographic or audiovisual equipment of any type, including cameras, video or audio recorders, or players, are allowed without prior court approval. And 2, no person other than members of the judiciary, attorneys, peace officers, and court staff shall be allowed to carry a cell phone into the courtroom. All cell phones must be turned off before entering a courtroom. That seems, I don't know if I said this before, but that seems like you can't carry it in there, but it has to be turned off. I don't know. Kind of weird. I think maybe you can't carry a cell phone into the courtroom if it's on. I don't know what that means. Or do the judiciary attorneys and peace officer and court staff have to turn it off before entering? I don't know. It doesn't make sense. Poorly written. You would expect a judiciary to have better written orders, but I find that having done a fair few applications for an order to show cause rate contempt, I can assure you that most often judges' orders are pure shit, and they're completely unenforceable via contempt. And number 3, disruptive behavior will not be tolerated. Security staff may remove offenders from the building, and judges may hold violators in contempt of court. And there's the link to that. Nevertheless, so the court says there's all these restrictions. Nevertheless, which means that despite those restrictions, plaintiff entered without a mask. He entered the courtroom to observe a domestic violence hearing before hearing officer Gordon Bennett, who asked plaintiff to put a mask on. And that's an allegation at this. Also see the Bennett video at this timestamp. Plaintiff refused and began surreptitiously recording the interaction with his cell phone. Bennett video at 4 minutes. Hearing officer Bennett then instructed plaintiff to leave the courtroom, but plaintiff ignored the instruction. Same thing at 5 minutes and 8 seconds. Bennett then went off the record, left the courtroom, and requested assistance from law enforcement officers. Same video at 5:20. When hearing officer Bennett returned to the courtroom, the following exchange occurred. Okay, so Bennett says, "What's your name?" Plaintiff says, "I didn't give it. I'm sorry. Just trying to spectate a public hearing. Nothing more, nothing less." Bennett says, "Well, if you're just there to spectate, then you're not there to practice your First Amendment. Just there to spectate." But it says, "I can appreciate your wish to spectate, and I can appreciate that this is a public hearing, but you're not going to violate the rules of this courtroom." Plaintiff says, "Which rules are those?" Bennett says, "Put a mask on." Plaintiff says, "Oh, you want me to put a mask on? Tell you what, if you threaten me with arrest, I'll just leave." Bennett says, "I'm not threatening you with anything. I'm telling you, if you don't abide by the rules of my courtroom, you will leave. If you choose not to leave of your own accord, you will be escorted." Plaintiff says, "Would I be arrested or charged with anything?" Bennett says, "Well, if you continue this, I may charge you with contempt." Plaintiff says, "Okay, so there's a threat of arrest then if I don't do what you say right now." Bennett says, "Would you happen to have your phone out right now recording this?" Plaintiff says, "I mean, if there's a threat of arrest, I'll just leave." Bennett says, "Are you recording this conversation?" Plaintiff says, "The court is. There's a camera there." Bennett says, "You're right, the court is. By statute rule, I'm required to record." "Well, by statute." Plaintiff says, "Tell you what, son." This is to a judicial officer. "Tell you what, son. I'll just get a bigger team. We'll come back, sweetheart. All right, we'll be back." Sweetheart, son, sweetheart. Is it? Are you trying to say that you like little boys? Or you like your own son? Or what is that? Like son and sweetheart? I don't know. It must suck to be a Momo and not allowed to swear. On February 20, 2023, plaintiff posted a video of this interaction on his YouTube channel. See it above. And then number 6, the Torrance County Sheriff's Office later informed plaintiff who would not enforce the mask mandate in the courtroom or anywhere else. Bennett video at the first second. According to a letter from defendant Jason Jones that was attached to ECF number 1, so this is from an attachment to the complaint. So according to a letter from defendant Jason Jones, court executive officer of the 7th Judicial District Court, Mr. Jones, to plaintiff after plaintiff posted this video, court staff were harassed, quote, on plaintiff's behalf and, quote, impacting the court's resource. That's from the letter of March 1, 2023, attached to the complaint in ECF number 1. It's the second attachment. Thus, on February 28, 2023, the Chief Judge of the 7th Judicial Circuit, defendant Murphy, Chief Judge Murphy, issued an administrative order, quote, in the interest of the safety and security of judges, special commissioners, hearing officers, and other court personnel, barring plaintiff from entering the Torrance County District Courthouse in Estancia, New Mexico, unless appearing for a hearing or having specific court business, not business with the court, but specific. Oh, they're off after something. Oh, you're back. So they have to have court business, i.e., the court's business, like business that the court is there for. In which cases, plaintiff shall be escorted and accompanied by the Torrance County Sheriff's Office while in the building, and that's administrative order, again, attached to the complaint, ECF number 1, the first attachment. Getting a little breezy. The administrative order requires that upon entering the Torrance County District Courthouse, plaintiff shall enter the sheriff's office and identify himself, quote, as being an obstinate visitor, alerting law enforcement that he must be escorted and accompanied pursuant to this order, effective March 1, 2023. Again, referencing the attachment to the complaint. On March 1, 2023, 2 officers with the New Mexico State Police delivered a copy of the administrative order to plaintiff. That's ECF number 1 at paragraph 15. They also delivered to plaintiff a copy of the letter of March 1, 2023, ECF number 1 at 19. According to defendants, plaintiff thereafter, quote, sought to harass court staff at the courthouses in the 7th Judicial District. That's from ECF number 29 at 4. ECF number 29 at 4. Do that. It's already there. It's already there, you bastards. I'm going to do that. And I'm going to do that. And I'm on page 5. On page 5. Jenny 5 is alive. I'm going to go back. You see up number 29. Number 29. Response. This is the response to the complaint. That's interesting. This is a response to the complaint. Ooh. I thought this was a response to the motion contained within the complaint. Interesting. Download! Do it now! Ow. Ooh. Okay. Where are we at? I'm sorry. I got a little excited there. Look at it. Here we go. A little excited. A little chub at 4. Let's go to Quattro. I'm going to go to at 4. 1, 2, 3. All right, here's the issue. Here is the issue. That is not a verified response. That is not a verified response. I don't think anybody looked at this one, the declaration that declares that the because normally it's a verification. So this is just weird. I wonder if they had intended the complaint to be verified. Verified just means that there's a declaration at the end of it. You know, I've read the foregoing, and it's true and correct, except for those things that I say on information and belief. And as to those things, I believe that they are true and correct as well. And you know what? I'll bet this empty page 16 was supposed to have the verification on it. It was supposed to have the verification on it. I'll bet. And then they probably didn't realize they fucked up, and they didn't realize that they done fucked up until August, and they were saying the motion for entry default, and then they realized they had a proof issue because they didn't have any declarations or anything to support their request for default judgment, and that's why they did this. But then they didn't fucking tell anybody. So when the defendants filed their response at 29, nobody fucking knew that it was not that the complaint was verified, because, well, why would you look at a notice of, what do they call it? They call it a notice of briefing complete. Why would they do that? Yeah, it's fucking weird. It's weird. I have not researched copper sulfate yet for my tanks. Again, I have invertebrates in invertebrates, and my understanding is that copper, number one, will kill any invertebrates in it, and number two, gets into the silicone and stuff, and it can actually fuck with later invertebrates. So, yeah. I am a boomer, Neil McDonald. If you were Norm McDonald, I'd have a lot more respect for you. Team Skeptic, you have a funny thing. You're not a mod on my channel, are you? Because you have a thing. Does that just mean that you're verified or something? I don't know. That's interesting. How do you get that? That's pretty cool. That's pretty cool. Did I get myself a bottle worm? Those are salt water. I don't do that. Neil says he loves me. Aww. So, yeah, so they are, it just says, according to defendants, plaintiff sought to harass. For example, a March 23, 2023 letter from Mr. Jones to plaintiff accuses plaintiff of, quote, entering the Moriarty Magistrate Court for non-court business and being disruptive and threatening the courthouse. That, again, the court is citing back to the complaint, which is now amended, or now verified. Consequently, Murphy issued an amended administrative order barring plaintiff from entering other courthouses within the 7th Judicial District, and specifically those in Torrance County, yada, 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 unless blah, blah, blah. Going back to the amended administrative order, again, attached to the complaint. Sometime after Murphy issued the administrative order, plaintiff visited the clerk's office without law enforcement escort and recorded the interaction. So he recorded the interaction. See, court clerk tries to force an escort on me, YouTube. During that visit, the following exchange occurred. Where's your escort? Excuse me. Where's your escort? Now, this is supposed to be 28, 2023. Hold on a second. Hold up. Wait a minute. Where do they have March 1st. So March 1st, on March 1st, Freeman was served March 1st. Okay, so March 1st he was served, so he knows. He has no reason not to know. And then he records a video and he posts it on May 28, 2023, available there. During that visit, the following exchange occurred. So he knows that he is required to check in at this point. He has been served with the order. Clerk, where's your escort? Plaintiff, excuse me? Clerk, where's your escort? Plaintiff, what do you mean? Clerk, you are only supposed to be here on official business with an escort. I said, where is your escort? Because per the court order, you are required to be escorted by law enforcement. James says, an escort? This is, you remember my little tutorial on midwit arguments? This is a midwit argument. According to Coded, this would be just ask you better questions. It's a clarifying question. Clarifying. It's important to clarify. And the clerk is moving the goal, shifting the goalpost. Straw man argument because he's not clarifying. It's a clarifying question and stuff like that. But this is midwittery. This is classic midwittery. Clerk says, yes, sir. Plaintiff says, yeah, I'm pretty sure prostitution is illegal in New Mexico. You see what I did there? You see what I did there? Escort, prostitute. Semantic arguments. Classic midwittery. I don't know if you're trying to solicit me right now. I don't know if you're trying to solicit me, but I don't appreciate it. Matter of fact, I think I'll head to the sheriff's department right now and let them know you're trying to solicit me. Is that what you're doing? Clerk, no. Plaintiff, are you trying to be my escort? Clerk says, I said, where is your escort? Because per the court order, you are required to be escorted by law enforcement. Plaintiff, so you're trying to be my escort? Clerk, no, sir. Plaintiff, how long have you been in the escort business? Gay. The complaint alleges that on May 18th, 2023, plaintiff attempted to attend a public hearing, quote, as a member of the press to report on the case in a criminal matter before the Honorable Mercedes Murphy by way of a video conferencing platform, ECF number 1, paragraph 25. After dialing in to the public hearing via the video conferencing platform, Murphy summarily ejected plaintiff from the video conferencing platform and from the public hearing without providing plaintiff notice and an opportunity to be heard on the matter of whether he could attend the public hearing. Would you be visiting the court, entering, hold up, wait a minute. Which one was it? Which one was it? Which one was it? ECF 1, 4. If you are required to be in court, in court. How was it? What was the court? All right, here we go. That doesn't prevent him from entering. No prevent. Such an excellent job. James took such good care of these documents. Entering. Entering. So I don't see anywhere in there where he was specifically ordered not to attend hearings by way of a video conferencing platform. On May 24th, Hoff issued an order excluding plaintiff from a hearing in a civil matter that plaintiff planned to attend as a member of the press and the public, citing an order. So at section 27, where were we at? So this is also from the complaint, citing order excluding ECF 1.5, order excluding presence. That's May 24th. So that's after May 18th. Well, what was this one? That was 5. That was 5. That was this one. That's in a specific case, though. The complaint alleges that on multiple dates, defendant Rossignol has either refused service in the clerk's office or has required police presence to harass and intimidate plaintiff when he entered the Estancia District Courthouse for the purpose of conducting court business associated to making records requests. Again, citing to the complaint. On June 8, 2023, Ms. Rossignol had a sheriff's deputy remove the plaintiff from the courthouse, again citing to the complaint. On June 9th, plaintiff filed the instant complaint for declaratory and injunctive relief. Asserting the following causes of action, claim under 1983, predicated on violations of the First Amendment rights to freedom of the press and speech, which plaintiff characterizes as viewpoint discrimination. And then we have 9 and 10. All right, 9. It is unclear from the complaint, the motion, and reply what, quote, viewpoint, end quote, defendants are allegedly discriminated against. So the problem is their order bans all video recording and all cell phones and all disruptive behavior. Viewpoint discrimination would be like protesters can't come and video, but people who aren't protesting, who just want to support the judiciary or whatever, can video record. That'd be a viewpoint discrimination. It's a lot easier to do with. It's a lot easier to do. Like if it's a protesters can't record on court grounds, that's viewpoint discrimination. But because especially and then there also could be like a de facto, like if actually the court doesn't enforce it unless you're a government accountability activist or something like that. So yeah, it is unclear what the viewpoint discrimination would be, and they need viewpoint discrimination because I'm going to bet a nickel that the court is a non-public forum, and in order to prevail on a non-public forum, you have to. Well, one of the easiest way to prevail on a non-public forum case, First Amendment non-public forum case, is to show that the restriction on First Amendment rights is viewpoint based. So, like for example, an easy one is the abortion one. You can't protest against abortions near this particular clinic, within X feet of this particular clinic, but you can protest anything else within X feet of that clinic. Well, that's viewpoint discrimination. If they have to look at the sign you're holding to see what your viewpoint is before they know if you've broken the law or not, that's classic viewpoint discrimination. And then the 10th one, footnote 10, is the complaint does not specify which defendants count 1 is asserted against, but Murphy and Poff are the only defendants named in count 1. The court's saying, like, I'm going to assume that this is against Murphy and Poff, but okay. And then it's citing to the complaint, and then 11. 11, the complaint contains 2 paragraphs numbered 30, the court citations to paragraph 30, and then in parens 2 and parens refers to the second paragraph 30 sequentially. Count 2 alleges a claim under 42 U.S.C. 1983 predicated on a substantive due process violation or violations, 12 and 13. The complaint contains 2 paragraphs. The complaint does not specify which defendant's count 2 is asserted against, but alleges that the defendant's actions constitute the deprivations of those rights contrary to substantive due process. So it appears to be against all defendants. And again, 2 paragraphs 31. So 32, and then in parens 2. First and second 31. Count 3 alleges a claim under 42 U.S.C. 1983 predicated on procedural due process violations. That's 14. The complaint does not specify which defendants, but it's probably Murphy, Poff, Jones, and Rossignol. And then count 4 alleges a violation of Article 2, Sections 17, 18, and 23 of the New Mexico Constitutions against defendant 7th Judicial District Court only. Plaintiff attached to his complaint the administrative order, the letter of March 1, the amended administrative order, the letter of March 23, and Judge Poff's order excluding presence. Plaintiff seeks a declaratory judgment, damages, a temporary restraining order, preliminary and permanent injunctive relief, attorney's fees, and costs. Again, citing to the complaint. And I keep saying citing to the complaint, and you'll see why, but citing to the complaint. Plaintiff incorporated into his complaint a request for a temporary restraining order on citing to the complaint. On August 10th, so in the future, I'm not going to mention what it's citing to unless it's not the complaint. On August 10th, plaintiff filed a notice of completion of briefing to which he attached a declaration in support of his motion and verifying the allegations contained in his complaint. That is to the notice of completion of briefing. The declaration states, inter alia, I've never been obstructive or instructed any person to unlawfully interfere with the business of the 7th Judicial District Court. Now that's a weird thing for the court to point out, especially YouTube appears to hate me. Well, I'm on. The wind is probably going to be messing with this recording. Sorry. Hopefully YouTube gets it or whatever. And I apologize. I'm in the country. I've got a little dish thing up there that says that tries to connect to a satellite or something like that. So the wind is probably messing with it. But anyway, I will soldier on as much as I can. And 5, I've never instructed or used any language that would cite any other person to act unlawfully towards the 7th Judicial District or any employee thereof. The declaration also provides URLs from videos posted to plaintiff's YouTube channel, including the videos transcribed above, which the court has viewed and considered. Subnote 15 or footnote 15. 2 of the videos are no longer available. That's weird. That's weird that he would make videos that he's using as evidence that he cites to unavailable. That's weird. You know what? You know what, James? That's probably spoliation. I'm just guessing. I'm not an expert. I'm not a New Mexico attorney or anything like that. But you can't make spoliation any more clear than actually including a link to your video in your complaint and then making the video not available. That's pretty clear. Defendant subsequently appeared in this case, ECF number 26, and filed a response to the request, ECF number 29. Defendants filed no affidavits in support of their response, but they did provide the court with copies of the videos transcribed above, which the court has viewed and considered. So the defendants had copies. Crazy. And the videos were transcribed, apparently. So, nice. Transcriptions are awesome. It's easier to read than watch it. Because defendants have appeared in this case and have responded to the complaint's request for a temporary restraining order, the court will construe that request as a motion for a preliminary injunction. Hereinafter, the motion. Court will construe that request the plaintiff's request for temporary restraining order as a motion for a preliminary injunction. The primary differences between a TRO and a preliminary injunction are that the TRO may issue without notice to the opposing party, and TROs are limited in duration. So the legal standard of preliminary injunction is an extraordinary remedy. Extraordinary means it's very unlikely to be granted. It is the exception rather than the rule. As such, it may only be awarded upon a clear showing that the movement is entitled to such relief. Preliminary injunctions are extraordinary remedies requiring the movement's right to relief be clear and unequivocal. To obtain a preliminary injunction, the movement must show, number 1, a substantial likelihood of success on the merits. 2, irreparable harm to the movement if the injunction is denied. 3, the threatened injury outweighs the harm that the preliminary injunction may cause to the opposing party. And 4, the injunction, if issued, will not adversely affect the public interest. Laura Rader says, easier for you legal wannabes to read maybe. Real constitutional law scholars use audiobooks and oral arguments for everything. Not to mention ChatGPT. So then 16, moreover, 3 types of preliminary injunctions are disfavored. They require a movement to satisfy a heightened standard. So there's a heightened standard to some. There are, number 1, preliminary injunctions that alter the status quo. 2, mandatory preliminary injunctions. And 3, that mandatory means that make someone have to do something. And 3, preliminary injunctions that afford the movement all relief it could recover at the conclusion of a full trial on the merits. When seeking a disfavored injunction, the movement must make a strong showing both on the likelihood of success on the merits and on the balance of the harms. Here, plaintiffs or defendants do not argue plaintiff is requesting a disfavored type of preliminary injunction to which the heightened standard applies. Interesting. A party seeking a preliminary injunction must demonstrate all 4 of the equitable factors weigh in its favor, and a plaintiff's failure to prove any of the 4 preliminary injunction factors renders its request for injunctive relief unwarranted. I'm not jerking off under the table, or am I? Discussion. Plaintiff argues that all 4 factors weigh in favor of an injunction, and citing again to the complaint, also citing to ECF number 33, that would be the reply. Defendants argue that none of the factors weigh in favor of an injunction. 17, footnote 17. Defendants further accuse plaintiff of spoliation of the evidence, but do not move for relief. Plaintiff initially argues that he's likely to succeed on the merits. ECF 1 at 12 to 13. However, in this section of plaintiff's motion, mentions only the substantive due process claim. ECF number 1 at 12 cites the legal standard governing equal protection claims. Oof. Oof. That's a big oof. I only have one hand. Oh, I got 3 dogs. This is confusing. All right. They're cutting each other off at the pass. Okay, that's a big oof. He argued the wrong standard. And summarily concludes, hello again. Okay. And summarily concludes, without citing any supporting authority, that plaintiff's fundamental rights protected by the First Amendment are clearly abridged, and he was afforded no notice or opportunity to address the abridgment of those liberties. Plaintiff finds that, or the court finds plaintiff has failed to satisfy his burden of establishing a substantial likelihood of success on the merits of his claim. Plaintiff's motion wholly failed to identify the elements of his causes of action, i.e., he didn't argue the right fucking things. That's the oof. That's the big oof. Like you didn't identify the things you needed to identify. You didn't argue the things you needed to argue. You were arguing an equal protection claim instead of a due process claim. See? Substitute process is not the same as equal protection. That's a big oof. If you argue the wrong thing, that's bad. It means he didn't argue the right thing, which means he didn't show what he needed to show. Nor did he cite any legal authority supporting his claims, which is grounds alone for denying the motion. Now, here's a fucking problem. Here's the problem. Let's go back to the complaint. This is the complaint. Here's the complaint. There is no memorandum of points and authorities. There is no memorandum of points and authorities in here. There is no. So he didn't cite the right test, and he didn't include a memorandum of points and authorities. Big oofs. So because he used the wrong standard, he did not use authority, no memorandum of points and authorities, establishing the elements that he needed to prove. At least one court addressing similar facts determined that restricting an individual's access to a courthouse due to disruptive behavior did not. Hold on a second. Did not constitute a violation of that individual's First and 14th Amendment rights. See Mead versus Gordon. See also Huminski versus Corsones. Court, administrative, judicial, and other officials must at least have the ability to close a courtroom door to any person whom they reasonably think may pose a threat to person, property, or decorum. A potential spectator may be excluded from a courtroom on a simple issue of propriety, reasonably unacceptable dress, unruly behavior, efforts inappropriately to communicate views in the courtroom, possession of personal property banned from the court, e.g., cell phones, cameras, or recording devices, and the like. In his reply brief, plaintiff argues for the first time, which is a bad sign, the defendant's actions constitute a prior restraint on the freedom of speech. 18. Neither the complaint nor the motion characterize defendant's actions as prior restraint on speech. And he's substantially likely to succeed on the merits of his claims because, quote, any system of prior restraints of expression comes to the court bearing a heavy presumption against its constitutional validity. However, assuming arguendo, this argument is properly before the court, which it's not, a party waives issues and arguments raised for the first time in its reply brief. Plaintiff cites no authorities supporting his argument the defendant's actions in this case constitute a prior restraint on speech or expression. Neither the administrative order, the amended administrative order, the order excluding presence, Chief Judge Murphy's act of excluding plaintiff from the video teleconference hearing, nor Ms. Rossigal's alleged of refusing to serve plaintiff in clerk's office actually restrain plaintiff's speech or expression. Rather, they restrain his access to court hearings and files. Plaintiff has cited no authority, binding or persuasive, holding that restricting an individual's access to court hearings and documents constitutes a prior restraint on speech or expression in violation of the First Amendment. See this, finding an order excluding press from a courtroom differs substantially from a gag order prohibiting the press from publishing information already in their possession, which is a classic prior restraint. And see also this case, finding that a judge's refusal to permit the press to access a case file while the case was pending did not constitute a prior restraint on speech. And also this case, this is not a prior restraint case. NBC is not restrained by the district court's order from publishing or broadcasting documents or information in its possession. Rather, the case concerns the right of the public and representatives of the media to have access to documents filed in a district court hearing at the preliminary stages of a criminal prosecutions. See United States versus Cianfrani, finding that limiting the media's access to a pretrial suppression hearing did not constitute a prior restraint on speech and did not violate the First Amendment. For these reasons, plaintiff has failed to carry his burden of establishing a substantial likelihood of success on the merits of his claims. See this case, finding the plaintiff failed to show a substantial likelihood of success on the merits where he offered only conclusory allegations and cited no case law in support of his claims. See also this case, White versus Alcone Film Fund, finding plaintiff's conclusory statements that he had shown a substantial likelihood of success on the merits, bereft of any legal support, is plainly insufficient to carry his burden of showing a substantial likelihood of success on the merits of his claims. Because plaintiff failed to establish a substantial likelihood of success on the merits, the court must deny his motion. See this case. And then all right. Okay. So all of this stuff. So he did not, the problem is that the lawyer fucked up and he did not show the elements and argue the law around substantial due process violations. That's the problem. Now, I'm not saying he would have won if he did, but the court would have had to actually consider the points more thoroughly. But the court can hand wave this away because you didn't cite the right law and you didn't argue correctly the elements. You tried to argue equal protection elements when you're asking for substantive due process violations. So that's the problem. So now keep that in mind. Let's see what we got here. So then we have a motion to recuse. This guy, this attorney, this agricultural attorney, Western Ag Resource and Business Advocates LLP, by A. Blair Dunn Esquire. He had lots of other things have pointed out that he has lots of issues with recusing judges, or trying to recuse judges, I should say. So this is an expedited motion to have the judge recuse herself. Now she gets to choose whether or not she grants this motion or not. You can appeal it, but she gets to choose. Now, if you want a further, closer reading of this, go to Frog. He read it in a delightful British accent. All right, so multiple instances of service awards requiring blah, blah, blah. So gave him too much time, et cetera, and then on a second. There was one thing in here that I wanted to point out. So the court did not. He thinks that the court gave credence to what the defendant said, but the court's decision was made based on the fact that the plaintiff, in his complaint, in the moving paperwork, the court construed part of the complaint as a motion. In there is no law to back up his assertions. He pled the wrong elements. He played an equal protection case instead of a substantive due process case. But he's saying that the court took the statements that the defendants had made as true. But you saw going through there's only a few references to what the defendant said, and that was just like, they argued this, and then here are some of the things in the complaint. Like, here's the letters in the complaint. Here's the orders in the complaint that the court can rightly consider. But again, it was just laying out the facts. The substantive portion of the judge's order was, you didn't fucking plead the right shit in your motion. So, and then he's all pissed off because Strickland also required the plaintiff to show cause why his complaint should not be dismissed for the lack of prosecution, because defendants remained in default, refusing to file an answer to the complaint, or plaintiff must file a dismotion or a disfavored motion for default. That's not accurate. What the court said is that you have to shit or get off the pot asking for a default judgment. Plaintiff shall have until this time to file a motion for default judgment. So once you get the default, the defendant is precluded from filing an answer. Generally speaking, a defendant cannot defend in the case anymore. That doesn't mean you win. It just means that they can't defend. So if you can't plead sufficient facts to prevail with a judgment, well, that sucks. You're not going to get a default judgment. But the defense can't offer anything. They can't participate because there's the default. The default judgment is what you get after a default, or what you theoretically could get after a default. So you've got the default, dude. Like, you got the default. The court's like, hey, you got the default. Piss or get off the pot, bro. Like, let's go. Let's go. Now is where you see if you have what it takes, if you have the facts to get the judgment. You've got the default. Can you get the judgment? And that's what the court was asking for. So it's just really unclear as to why he thinks that this is this is a spot of the fact. It's clear that the defendants of the party that should be required to show cause. This is why they not provide an answer to the complaint. They literally can't at this point file an answer to the complaint because there's a default. You dumb shit. Like, you're an attorney and you're embarrassing, bro. You're embarrassing me. What the fuck? There's a default. Oh, they should in order to show cause, should issue as to the defendants as to why they haven't answered the complaint. Well, they'd be like, because, Your Honor, there's a fucking default. And why they should suffer default judgment. Like, the court is telling you, bro, you have to file a motion asking for default judgment in order for me to give it to you. I'm telling you, file your fucking motion. Let's go. It's not the defendants don't have to say why you shouldn't. There's a default. They don't get to participate. Fucking hell. Anyway, it was all pretty much dookie. Yeah, it was all pretty much dookie. They served wrong. I don't remember exactly why this matters. This is an affidavit from Springer. I don't really care about it. Frog read it pretty well. This motion to set aside the default was dookie. It was absolute dookie. Again, written by an attorney. I don't know what's in the water down there in New Mexico, but what do I have on the grill tonight? Apparently bourbon, probably. I don't know. No, I don't have bourbon on the grill. I don't have bourbon in the house. I don't have anything on the grill. My wife was making something. I smelled. She was cooking squash, and she also does this vegetables where she puts them on a cookie tin with garlic, a little bit of olive oil, and like some bacon pieces for the flavor, and she bakes it until the kind of caramelizes a little bit. It's really good, and probably some sort of meat, but I don't know exactly what. She keeps me fat, but anyway, yeah. Like I don't know what's going on in New Mexico because this is some pretty like shit tier writing. In this one, oh yeah, the thing in this one was the one thing I found was fucking hilarious. They argued the same thing twice. Like they double up the arguments for all three of these things, but they argue that they have a meritorious defense, but they never fucking set forth what their meritorious defense is. They just state we have a motion to defense. Defendants will explain in a separate motion to dismiss how their version of the facts, if proven at trial, would constitute a legally cognizable defense to the action to plaintiff's allegations. In a motion to dismiss, the court has to accept, well, the court should accept all like reasonably plausible facts pled in the plaintiff's complaint as true, and any uncontroverted facts as true, and then can consider any facts that the defendants plead that aren't controverted by the plaintiffs that are reasonably likely to be true. But you don't do a motion to dismiss for facts if proven at trial. Because like if it has to go to trial, if you have to prove it, that means there's a triable issue of fact. And literally that's one of the things, like 12b6 is failure to state a claim. That means like even if everything that the complainants allege is true, you lose. Notice how that has nothing to do with if the defendant's facts went to trial, they'd be proven true. It has nothing to do with that. Like I don't even know. I don't even know. And then fucking Freeman's attorneys didn't even serve right. Oh, so mad. And then Springer, he has this motion for a stay and injunction pending appeal. That I don't think he's going to get either, to be honest with you. He might get the stay pending appeal, but not the injunction, because again, he doesn't have. Well, the injunction he's requesting is that Springer gets to go to the court as long as he complies with all applicable rules. And no, I don't think so. I think he's going to have to comply with the court orders to go to court. So there you go. JJ Thomas asks, well, how are you sneaking shots to maintain your alcohol status? I've got a straw in my sleeve, so every time I rub my nose, I'm actually drinking from a straw. People are like, you talk a lot about alcohol. You seem really defensive on it. Like, I've been accused how much of being an alcoholic? Like, I mean, I don't know. I don't really care. It's just ridiculous that it's just ridiculous. I don't want to fucking talk about coded. I don't know. I don't know if I want to go through all this. All right. Well, we don't have a lot. Jason R says, number one back at you. WTT says, hello, children. Paul Berry says, good evening. Jason R says, hello, Merb. Matto says, chat. Dave says, chat be chatting. Nevea says, we good now? Scissors says, what was Coded going to do without chat? I don't know. Masturbate more? Paul Berry says, let the innuendo begin. Logan Sandman says, hey, everybody. Pants asks, am I still blocked? Paul Berry says, Pants, yes, you're still blocked. J5 says, dying, I actually made the beginning of one of your lives. Scissor says, chat window, sweet. WTT says, verbally blocked, that's the real deal. Pants says, spanking would be better, probably. Nevea says, I like the civil rights lawyer. Well, okay. I've never actually watched one of the civil rights lawyer's videos, so, I mean, maybe he's a cool dude, maybe not, I don't know. But he fucking swing and a miss on that last one. Baby Tuck says, sweet, I finally made it. Hit the like button. Hit the like button. I don't really care. WTT says he let you back in and out and in and out and in and out. Pants says, thank you, Caddy. Nevea says, that didn't happen. I saw all the videos. Okay. Scissors asks, which tab is porn? All of them. Bill Cook says, I remember this one. The officers had medical issues and blamed the prisoner for throwing drugs on them. Turned out they tased each other. Well, I mean, if so, that could come out in court. But I don't know. I don't know. Like, why would they tase each other? Like, that's kind of fucking weird. I don't know. J5 says, so this civil rights lawyer is as smart as BSBT then. I don't know. Like, you fucking swing and a miss on that one, though. Kevin says, Springer has been drinking too much from the DeCastro coffee pot. They need to try decaf next time. Springer's a Momo. He's not supposed to have caffeine. He wears magic jammies. J5 says, Merb, surely you're not implying that an attorney would say something he doesn't believe strictly for money. I'm going to have to get some pearls to clutch. Clutch away. Bill Cook says, you know Merb is rich. He pays 20-ish cents for these documents and doesn't need to beg us to contribute. That's true. I have a whole cup thing of change in my car that I never use because who carries change? That's crazy. Tay's auditors laugh like hell says, has Felipe proofread these motions? I don't know. Felipe has been like a no-show for my Discord for freaking months. I feel like I kind of miss him. Kevin says, who's coded? What's his channel name? I can't find it. Well, good luck. Fish Fart says, hello. Tay's Otter says, Merb loves fish farts. You found me out. Yuri says, peck, haha, oh peck. I don't know what that means. J5 says, OMFG, I just found Celebrity Deathmatch on Paramount Plus. Well, congrats. Chronic says, is coded friend .001, maybe? Maybe. J5 says, at Chronic, bingo. I'm Spartacus says, I am just a first-year Merb Manson cult member. Okay. Paul Berry says, Merb, please put this on 1.75 times. I like to draw it out a little bit. I like to, make it last. Because it's just 3 pumps and a dump. So, I mean, you could have and done, or you could have pump, pump, pump. And enjoy it for that much longer. Chronic laughs. Bare Legal Brief says, you are doing great, Merb. Bare Legal Brief says, not sure he put himself on 1.75 times, Paul. He can. Team Skeptic says, good to see you, Merb. Hello, Jack. Good to see you, team. Today's Otters off like us says, Merb, do you ever listen to Armstrong and Getty? No, I don't. I've heard of her. I've never listened to her. J5 says, at Team Skeptic, and he's in. Team Skeptic says, J5, lol, how you doing? Joe Cook says, hi, Skeptic. Today's Otters off like hell says, Team Skeptic is out. J5 says, Team Skeptic, good to see you. Pat's Cat says, oh yeah. Team Skeptic, grats again. Team Skeptic says, hey, Tay's Otters off like hell, good to see ya. Team Skeptic says, hey, at Pat's Cats, all the cool kids are here. Pat's Cat says, TTU. Team Skeptic says, TTU, baby. Laura Rader says, if they weren't overly vague and not written well, there'd be less need for judicial decisions about what the fuck they mean. Gotta keep the system churning. I don't think that the courts really want vague orders. They want people to follow them. They want them to be clear. They want them to be enforceable. But the difference between what is enforceable and what isn't enforceable is a pretty fine line. And sometimes hard to get. Team Skeptic says, hey, Bill, good to see ya. Logan Salmon says, Team Skeptic, congrats on the silver play button. J5 says, why do they think being threatened with arrest are magic words? Why do they think being threatened with arrest are magic words? I don't know, to be honest with you. It's probably to say that they're like trying to preserve their the claim for a lawsuit. You know, because you don't have to get arrested to have a cause of action if you comply. Um, because it, like if someone orders you out of a building and you comply, like if a government official, not just a cop, orders you out of the building and you comply, you can still sue, like for whatever your cause of action was, instead of being arrested for not leaving, etc. But I think they just think they're preserving it or something like that. I don't know though, because Freeman thinks a lot of things, and like Broken Sister, Broken Trust think a lot of things that don't fucking make any sense. So I really don't know. I'm sorry. I wish I could give you a better answer. Laura Rader says TTU skeptic. Team Skeptic says thanks, Logan. I appreciate it. And TTU baby to Laura. John the Lab Man says strange how Freeman seems to have trouble covering a courtroom. Yet all these years, other media has been covering trials without video equipment, but we're able to cover trials. Cameras should be in court, and most courts I find have cameras in them. That doesn't always mean you can watch them, but there's cameras in courtrooms. I don't know of any courtroom that I've been in that doesn't have a camera in it. But again, I'm pretty much just limited to California. J5 says one of the reasons why constitutional originalism is ridiculous. Okay. Laura Rader says agreed. I've always believed that the Constitution was meant to be a living document, hence the amendment capability. Lol. Well, I mean, you know, if it's a contract, then everybody has to play by it. There is a method to update the Constitution, and if it was meant to be, a living document, i.e., if it was meant to be reinterpreted to the standards of the day, then why did they need to put in all that language about how to amend the Constitution? It seems to me, and maybe I'm just silly, it seems to me that they didn't intend it to be a living document, that they intended it to be more like a binding contract with a provision on how to change said binding contract. J5 says, Laura, hey, and exactly. Pat's Cat says, what the fuck? Laura Rada says, hey, J5, Laura, my Roku went black again, got a refresh, burb. Scott Rickoff says, research copper sulfate yet for your tanks. I haven't. I have researched it, but the copper part's the bad part, at least for invertebrates. Pat's Cat says, it's gone. Scott says, trace amounts. Pat's Cat says, where to go? J5 says, Laura Raider, that sucks. I watch this on my PC browser. Might have to try the Roku YouTube app. GMK Midwit says, Laura Raider, I think there is historical material indicating the expectation that the Constitution would or should be amended every 20 years or something. Probably through the amendment process. Pat Scott says, J5, you see him. Loretta says, I do both J5 so I can enjoy the big screen in the living room but can't chat with Roku, so I keep the browser going for chatting. Neil McDonald says, Boomer. J5 says, Pat Scott, see whom. BB says, you got to give yourself a nice bobbit worm, or you get yourself a nice bobbit worm for your tank yet. And no, those are salt water. I love fresh. Neil McDonald says, we love you, Merb. Love you back. Laura Rader says, try refresh. Pat Scott's work for me if the stream glitched on you. Laura Rader says, I don't know that GMK, but it makes sense if you aren't just trolling the little 20 years I mean. J5 says that Laura Rader, I have my PC hooked to my AV receiver with HDMI. I can do it either way. Good old Gen X nerd here. Team Skeptic says, Merb, yeah, checkmark just means verified. Dave says, any comment about Chili's new 5A card? Oh, yeah, we can go over that. We certainly can. I actually have it. Sorry, it's blurry, but this is what I've got. So, cop citing. Start filming states, I invoke my First Amendment right. If they're not asking you questions, why would you do that? And if you keep talking, which it seems like most auditors can't do, then, well, it doesn't mean anything. You actually have to just the easiest way is just to shut up. You don't have to say any magic words. Just don't answer any questions. If you have been answering questions and you realize that you've been answering questions, then you specifically say, I invoke my First Amendment right, and stop answering questions. But you could just say, I don't answer questions at the beginning, and then don't answer questions, and you're fine. And he's citing Turner v. Driver. I don't know if it says that in there. Does Turner v. Driver involve invoke my First Amendment right? What the fuck? I saw it as fifth, right? My mind thought fifth. I've never seen someone invoke their First Amendment right. That's fucking retarded. And no, Turner v. Driver does not say Turner driver, Turner driver, Turner driver does not say uh, it's a 5A cop card. Fifth Amendment. All right, no. Okay. All right. I'm going to have to make this bigger if that's what she says so you can see everything. So right out the gate, you have a bad citation. It's not Turner driver, it's Turner v. Driver. You have a First Amendment issue that's you don't have to invoke, and it doesn't say you have to invoke it in Turner v. Driver. And your right to film the police in Turner v. Driver is may be limited by reasonable time, place, and manner restrictions. So number two, let's see if number two is actually about the Fifth Amendment, because this is your Fifth Amendment cop card. So filming, cop approaches states alleged interaction or questions you. Filming, give legal docs. What legal docs are you going to give? Why are you going to give legal docs? And say, I invoke my Fifth Amendment right. Just don't answer questions? Fifth Amendment is unequivocal. Cop loses qualified immunity for questioning you. What? No citation. I don't think so. I don't think so. What actually happens if the cop questions you, then if you answer, then those answers are admitted. If you don't answer, then, well, you don't have a problem. But number one, the Fifth Amendment kicks in. No, Fifth Amendment's all the time. It's due process that kicks in on arrest. That's the Miranda warning. But all right, so let's step that one back. The only thing that's going to stop questioning is after you're arrested, when your Sixth Amendment right to an attorney kicks in. If you invoke your Sixth Amendment right to an attorney, if you say, I want an attorney, unequivocally, you have to say it unequivocally, I want an attorney. I don't want to answer questions without an attorney. I want an attorney. But the Fifth Amendment does not stop them from questioning you at all. And they don't lose qualified immunity for questioning you at all. And he has no citation to it at all. So that's pure bullshit. If the cop asks you to exit the vehicle, filming, exit, lock, show card, or state, I do not consent to searches and seizures. 1977, Pennsylvania versus Mims. Cop must believe you're armed and presently dangerous. To have him pat you down? Pennsylvania versus Mims, the cop ordered that was the driver out of the car and noticed that the driver was packing heat. He had a gun, and the cop patted him down and took the gun, and subsequently. So it's Terry v. Ohio, and facts available to the officer at the moment of search procedure warrant a man of reasonable caution in the belief that the action taken was appropriate. So remember in Terry versus Ohio, Officer McFadden had reasonable, articulable suspicion that Terry was casing a jewelry store for an armed robbery, which gave him reasonable suspicion that Terry was armed, because you don't do armed robbery without being armed, which made his frisk of Terry reasonable for the Fourth Amendment. Didn't have to believe he was armed and dangerous, just had to have reasonable suspicion that he's armed. No, and dangerous. Because you're armed. So you reasonably conclude the person who he had legitimately stopped might be armed and presently dangerous. If you're armed and you would be presently dangerous. Remember that Terry wasn't threatening anybody. He went up to a window, looked in, went back to the corner, talked to another guy. Did that like 5 or 6 times or 7 times. I mean, maybe even 20 times. I don't know how many times he did. But he was just walking up, looking in the window, walking back to the corner, talking. Then the 2 guys started walking. He met up with a third person, and that's when McFadden grabbed him. Thought he would be armed because armed robbery. You have to have reasonable, articulable suspicion that the person is that the crime is afoot and that the person is armed. Armed would be presently dangerous, I guess. So here's the logic. He was armed and thus posed a serious and present danger to the safety of the officer. Because he was armed, he posed a serious and present danger to the safety of the officer. The armed makes you dangerous. It's not like another thing. You don't have to be presenting a danger to people just by being armed. You're armed and reasonable suspicion of crime. So you need the reasonable suspicion of crime, and then the reasonable suspicion that you'd be armed in the process. And those two come together. You get the pat down. If the pat down produces the weapon, then you might have a weapons charge. So Pennsylvania versus Mims is normally cited for the cop being able to tell the driver to step out. So this is like not the bulk of the opinion. This is just, oh shit, it grabbed all of it. This is the second question. The second question. So this is the minority of the opinion. Like all of this is where they're talking about getting out of the car. So normally you talk about this like, do you have the right to tell someone to get the fuck out of a car? I don't know why I don't know why. I mean, it's not necessarily bad practice to lock the door. This car's garbage. The car is garbage. But lock the door behind you. At least close it. Uh, I don't think you have to lock it necessarily, but you should at least close it. If you leave it open, that makes it easier for them to for the plain view doctrine to kick in, for them to see what's in there. You know, from outside of the vehicle, they can look under the seats and whatnot without entering it. But even if they do enter it, I mean, you might have problems. All right, cop requests to search your vehicle. Say no. Say no. Filming, give consent, then revoke consent. Why not just don't give consent? Why give consent and then revoke consent? Why give consent and then revoke consent? Why not just say no? What? Hold on, I'm gonna ask chat. Chat, why the fuck would you give consent and then revoke consent? Somebody, what is Chili's argument for that? Why give consent and then revoke consent? I don't watch him, so I don't know why he would even say that. Give consent then revoke consent? Why not just not give consent? I don't know. That's stupid. Let's see what is that. Florida versus Jimeno. Like what? Like this? So in Florida versus Jimeno, Uh, they asked if they could search Jimenez's car. He said yes, and then the officer found cocaine inside a paper bag. He was charged with possession. They tried to suppress the evidence because he didn't specifically say you can open up the paper bag. You can go through any of the containers. And the Supreme Court said, well, he didn't put any limits on it. They asked if he could search the car, so they searched the car. And they searched all the stuff in the car. So, like, why are you citing this? Why? Anybody? The video Chili did. He saw a stop taking place, and an officer was searching the car with driver's consent. And Chili told the driver to revoke the consent and have the search stopped. But why not just not give consent in the first place? I don't know what kind of Adderall this dude was on when he made this, but he still thinks this is good, huh? All right. If a cop says he smells weed in a state with legal weed, with legal medical or recreational marijuana, filming, I guess this is if you're driving? Okay. Filming, show card or state smell is not probable cause. 2021 Commonwealth versus Barr. Never heard of that case. Smell is not probable cause. He's never provided any reason, logical. Well, has he provided any reason for it, logical or not? I don't know. I feel like there's something I'm missing, and I don't like to not know that. All right, common, oops, common, Commonwealth versus Bar. No, we're not gonna do it. There we go. I don't want all cookies. Sorry, I'm reading. Dun, 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 dun. Dun, 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 dun. Okay, so here we go. In Pennsylvania, the odor of marijuana alone does not amount to probable cause to conduct a warrantless search of a vehicle, but rather may be considered as a factor in examining the totality of the circumstances. So, if the cop does a pullover and says, hey, you know what? I smell weed. Does that, it by itself, allow him to search the vehicle? No. But you know what he could do? He could say, show me your medical marijuana card. And if you don't have one, oof. Oof. Now there's oof. Now there's oof. But I'm not entirely sure because this case does cite to Pennsylvania, their constitution. And this is Pennsylvania's application and understanding of their constitution as well as their application and understanding of the U.S. Constitution. And I'm going to go ahead and say I don't think that you'd want to rely on a Pennsylvania case. Apparently, this is the Tesh Lines versus Danforth of this particular card. He likes to throw in bullshit that doesn't. It's a state case. Cop says he's calling in a drug dog canine. Filming, show the card, or state extending the stop violates my rights. Well, you can't extend the stop to call it a canine without reasonable articulable suspicion. That's what he says on Rodriguez versus U.S. So you can't extend the stop without reasonable suspicion of something, right? So if you have only reasonable suspicion that the person might be speeding, or no, if you have reasonable suspicion the person is driving without a driver's license, like you run the plate, it comes back registered to someone who has a suspended driver's license, that'll probably give you reasonable suspicion to pull the car over. You go and you check and you ask for ID, and that person produces a valid driver's license. You realize it is not the registered owner of the vehicle who's driving. So your reasonable suspicion has been allayed. Now you no longer have reasonable suspicion, right? Well, then you can't start trying to manufacture other things to extend the stop. If when you go and you ask for the driver's license, you smell alcohol. Well, that gives you a new thing to do. But you can't, without reasonable suspicion, you can't extend the stop. So the thing is, though, it's just because he's calling a canine doesn't mean it's extending the stop, because there are cases out there where the officer had someone pulled over And while he was writing the ticket, he called in and had a canine come, and the canine came and started going around the car before he finished writing the ticket. Now, the court in that case, I forget which case it was. Maybe it is Rodriguez versus U.S. Let's check it out. 2015? Must have searched this in the past. Mm-hmm. Mm-hmm. So yeah, well, this case is the one I was thinking about. Um, but he'd given him back. So in this case, he'd given him back the documents. Everything was done, but they couldn't leave because he wanted to go walk the dog and around the car, and they said no, yada yada. So yeah, in this case, but just because there was a case where just because uh, the officer called the cop, it didn't do anything. Um, the the issue is whether or not it extends it. I don't remember what that case was though. I wish I remember the case. But yeah, as long as it doesn't extend it, they can have the dog run the car. So I think that was it. That was all of the stupidity, right? Yeah. And again, so the cop can't extend the stop or calling the canine without reasonable suspicion. He doesn't have to tell you the reasonable suspicion. So anyway, I caught about 5 minutes of Chili's live the same night. You went over the Wagner case, and Chili claimed he already had new filings to send. Well, that's not going to be fun for him. It's not going to be fun for him. Merb doesn't seem to have the narcissistic delusion of always being right. No, I'll be a culpa. I'm wrong. Anyway, it's been real. It's been fun. I wish I could say it's been real fun. Thank you, ladies and gentlemen, for stopping by. Have yourself, if I don't see you for the rest of the weekend, have yourself a wonderful weekend. If I am going to stream,